personal views and opinions expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss privacy issues with industry leaders around the world to tell businesses things that they need to know now. I am joined today by Jay Glasgow, who is the CEO of the Privacy Co-op. He always talks about value your rights. Jay and I met on LinkedIn. I think you sent me a message and you and I had some chats back and forth, and we had a call recently. And I am rarely ever at a loss for words, but some of the things that we talked about, I was just speechless. I say, oh my God, we have to put you on this podcast because some of the things that you were talking about are so spot on about the way privacy laws stand now, or the way laws stand in the US. I feel like you have such a deep understanding of how that works, and also understanding the privacy rights people have and what they don't have, and how to sort of work within that system in a way that I feel like a lot of people don't understand. So um, maybe you can give just a little bit more background about yourself and what you do and how why you're interested or why you're passionate about privacy in your work.
Sure. Thank you, Debbie, for inviting me on the podcast. I've listened to several of them, and your show is always exciting. I can see why I think you got awards recently for being in the top 10 podcasts. So it's an honor to be here. And as far as how I got into all of this mess and why I'm passionate about it, I wish I could say that I charted out my career, because it would make me sound a lot smarter than I actually am. But I think that there's a lot of convenient blessings and opportunities that just kind of fell my way. But for the past 30 plus years, I've been in the telecom industry largely, and have had the benefit of being in the room when a lot of innovation is happening. So I'm on, I don't know, 15, 20 patents, and all in the area of convergence and data use and big data. And when you talk about convergence, that's when everything was coming together around the millennium, around the year 2000, where telco and television and mobile communications and everything was merging. So, we just about couldn't turn around without having some sort of innovation. And early on, we realized that privacy was a serious concern. The phone company is certainly heavily regulated by the FTC and FCC and other authorities worldwide. So we had to be very careful about data use and privacy. So we looked at different ways we could help companies. I was a key in a publication into the public domain of a standard that's been adopted by many of the larger companies called personal levels of assurance about 10 years ago. And then from there went into big data with AT&T at the onset. So 6 years ago, I was brought in as the architect for consent management in big data. So when you're dealing with petabytes of data a day, and potentially 7 to 9 different uses of that data. Some of them are opt-out, some of them are opt-ins, some of them you can't have a say, like fraud, and others. We had to figure out how to deal with this when we're dealing with very, very large data sets, as well as transactional consent. And then very fortunate to, about a year ago, join the Privacy Co-op as the CEO. It was a real, again, a great opportunity to come in. So I guess I've just had a great view into some of the complexities that you deal with on your podcast.
Yeah, that's excellent. That's excellent. I think maybe similar to you, I sort of kind of rode the wave. It's sort of, data adjacent, I would say. So if you're someone who's been dealing with data over the years, this privacy thing has come up, and it's probably something that had been sort of a bullet list on a longer list of things, right? Where now so much more a focus because there's just so much more data being generated in different places. And then two, I mean, you have the experience of working in regulated industries that they have to get this right. Where the industries that aren't as regulated, they've been sort of, devil may care, I guess, about this, and they can't be anymore. So, I always say, um, uh, great wealth precedes regulation. So I think we're on the cusp of that.
Oh yeah. Oh yeah. I mean, in 2009, to that point, I was asked to be the tech lead and project lead for Project Fulcrum, which was identity across all of AT&T. So if you can think about the different forms of identity that a very large telco might be engaged with, and the laws that apply to that. And, we were learning all kinds of things like age of majority is totally different from state to state within the United States. I thought it was 18, but in some states it's 20, some states it's 21. And then from country to country, you have countries out there where the age of majority is different for a boy and a girl, right? It's kind of crazy. You see ages from 12 to 24 in the wild. So just looking at the laws and how they apply, not just to privacy, but to identity. And so again, very fortunate to have made that trek. It was painful at the time, but I'm glad now for all the learning. And I'm sure you're in the same boat.
Yeah, definitely. Yeah. So I run into that all the time about identity. Identity to me has been sort of in the background for many years. And I feel like it's going to be in the foreground for probably the next 10 years because it's going to be the center of a lot of what's going to be happening. So, yeah.
Oh yeah, Paul Windley and Kalia Hamlin will be glad to hear that. They've been running the the Internet Identity Workshop now. I think it's twice a year on the East Coast and the West Coast, and they've been doing that for oh my goodness, greater than 10 years. And so they'll be glad to hear that. I'm sure their audience and attendance is going to be going up.
Yeah, I tend to be right about these things. So I have a good feeling about this. And I've been talking about it for a couple of years. So I love to see that for sure. Let's talk about, obviously the privacy co-op, you work with people all over the world, but I feel like the US has peculiar privacy issues
Yeah.
in my opinion, and that a lot of that is based on something you touched on about, which is how things are different from state to state, and how we have kind of, we have some laws that are very sector specific, and there are some gaps in there. And I love you to just sort of give a more fulsome overview of kind of what you all do in the privacy co-op, and then get your view about what's happening in the United States as it relates to laws and kind of consumer or human rights and privacy.
Oh wow, what an excellent question. First of all, privacy is an individual right. It's a personal right everybody has. And typically, personal and individual rights are secured at a national level in most countries. Certainly here in the United States, the right to privacy is a national federal law issue. And if your audience thinks about it, you can't sell an individual right. There's no way to buy and sell individual rights. So the right to privacy cannot be bought or sold just as a basic legal theory. And that's true in most countries that we work. Now, publicity is something totally different. Publicity is contractual law. And contractual law is largely settled at the state level or local regional level in other countries. And contractual law is a right. It can be considered contractual rights. And it can be bought and sold. Now, in most countries around the world, they've done a pretty good job of keeping those two things separate, publicity law from privacy law. But about 120 years ago, with the advent of Hollywood here in the United States and the fame of celebrities and the legal clout that was forming in Southern California, you might have seen a kind of a conflation of those two things within the laws here in the United States. So it gets lumped together. And the same law that would, protect Cary Grant from having a photographer snoop up and do peeping Tom type tort violations by taking a picture in the kitchen window was largely applied to the fact that you could put, Cary Grant's photo on a box of Wheaties, which would be misappropriation, which would be more of a publicity law or contractual law issue. We just lumped all of that together and called it privacy. So there's some confusion now in the United States as people are wrestling with the fact that we're all on this trek for fame, individual fame. We want to publish videos on YouTube. We want to get likes on LinkedIn. We want to put ourselves out there, and yet we're dealing with these things and calling them privacy laws, when in fact they're really probably more contractual publicity law. And those are settled state by state. Now, where the privacy co-op comes in is that we started realizing that there's nothing new about individual rights being secured at the federal level. There's nothing new about contractual law being established at the state level. Just because we put the word tech in front of it, or high tech, or we put an I in front of a word or an E in front of the word, we feel like we have to go and write totally new law. But the truth is that Benjamin Franklin was trying to secure and reduce risk and liability for new innovative products back in 1753, before the country was founded. There's a set of common law around cooperative associations, what has evolved into co-ops and nonprofits, really two different classes of businesses. Now, the privacy co-op came along and said, can we do this? Can we take all of this existing infrastructure and framework as we understand it and just apply it to data? And we found success in that through the use of two pieces of paper. It doesn't get much more low tech than two pieces of paper. We have a piece of paper for our members to sign, and our members, you can become a member. Hopefully all your listeners will become a member of the co-op. Here's a shameless plug. I think it's $25 for a lifetime membership. So it's not like I'm out to make a ton of money here off of memberships, but you can become a member of the co-op. That's buying a share in the co-op. And sign a piece of paper where you're asking us to manage your affirmative express consent and the licensing of your information, right? Much like Cary Grant might have had an agent representing him for his face being on a box of Wheaties. So this is very much largely the publicity side of this. We guard the privacy side, but at the same time, we help our members manage the publicity side of this. And that's one piece of paper. The other piece of paper is for our affiliates, for businesses that come to the privacy co-op that say, hey, we have all these pressing global regulations around privacy, pressing down on us with these heavy fines. There was an outfit that was fined $6.5 billion under EU's GDPR a year and a half ago, right? So this isn't chump change. And it's only increasing as these governments see the possibility for increased, maybe even unlimited revenue through privacy fines and violations of businesses. They're setting up all of these tripwires for businesses to stumble across and say, oh, you violated another privacy law. You need to pay us $1 billion. Well, all of that money, is that going back to your listeners who are generating the data to begin with? Do the governments say, hey, the value that was added to the system was added by the common person using Facebook? No, they're just using that money for something else, right? So at a certain point, it starts to look and smell a lot like a tax or a taking, right? If you're generating the value for the platform, the value of the platform is making that platform billions of dollars. A government comes in and sets up some regulation and takes a big percentage of that money. It starts to look an awful lot like a tax, not on the business, but on you. It's your information that's generating the value, and the government is reaping the reward. So as we looked at this, we said, hey, for the affiliates of the privacy co-op, for businesses that are trying to find some sort of cover for these ever increasing regulations, perhaps they become an affiliate of the privacy co-op and license the use of our members' information. That's what we're brokering. That's what we're managing, is the information rights for our members, right? So this is a perfect union of two pieces of paper that are helping businesses come into compliance with regulations around the world, including, CCPA and US 74 here in the United States and others. As you've mentioned, there's 50 states now that have various forms of some regulation around data, as well as helping our members secure that, picture on the box of Wheaties, royalties or dividends that are due to them. So here's your opportunity. If you're generating the value by creating data, and some of which is information, then here's your opportunity to find an agent that will represent you in that and make sure that you're getting your fair share while we guard the privacy side of the house, right? So that's in a nutshell what we're doing as a nonprofit, as the cooperative privacy co-op. There are other authorized agents in the United States. Fairly famously, Andrew Yang ran for president this past cycle. And he, after stepping down from that effort, formed the Data Dividend Project, which is a nonprofit doing largely the same kind of work. There are others that are stepping into this. And where this is happening is, I heard a lawyer one time say, new law begets new business, right? There's new business opportunity when you have new law. And as the regulations carve out this role for an authorized agency, you're seeing more and more authorized agents pop up. But we like to think the privacy co-op is the best.
Very good, very good. I would love to talk about just. I think before the call we were talking a bit about one of the previous podcasts that you had listened to from Meme on Woody Way, where we sort of touched on the prospect of a federal data privacy law, and you sort of brought up one of these COVID laws, what I'd love to talk about, and then also the idea or the tension around federal data privacy law as it relates to potential preemption of things that states are passing right now, and then also a private right of action. That's a big question.
It's a big question, and we can peel that onion. First of all, let's start with everybody admitting that COVID tracing is reprehensible worldwide. We haven't found a great application of it yet. I would say probably the best area around the world that we found at handling privacy rights and data rights and human rights and still doing a good job of COVID tracing is in Alabama. Remarkably, they have a general counsel out of the Attorney General's office there in Montgomery that's working on this specific problem, has been since last spring. And she told us, as we were kind of exploring how different states and regions around the world are doing this, she told us that they were so concerned about it that when they realized they needed more people, which 35 states, I believe, have outsourced COVID tracing. In Alabama, when they went to outsource, they insourced. They went to UAB, which is a medical college in Birmingham, and had them come on board to help because they understood the HIPAA regulations that apply to patient data. Now, contrast that to the state of Texas. They're on the other extreme on this scale, where an outside outfit went through a bid process against some pretty heavy hitters like AT&T and Cisco and others that had, were under federal regulations. They were under FTC and FCC regulations, and probably would have done, we totally consider they would have done an excellent job with maintaining data security. An outside outfit called MTX Group from New York came in. My understanding is that they hired 2 lobbyists in Austin, Texas for $50,000 for 3 days work, and they ended up with a $295 million contract where the health department was turning over all COVID testing records to this private organization. Now, you look at their website, what are they doing with the data? Well, they have 10 products listed on their website. 9 of them largely are data collectors. And then there's one that sells data. It's really interesting to see what the one that sells data does. It looks like it sells insights to politicians that are running for office. Now, here we are a year into a 3-year contract, not a single audit. There's no ability for people to opt out that we've been able to find. So this organization is still collecting live data off of our citizens. The Houston Chronicle said that the language was meant to, quote, track us down and monitor us, end quote, right? So it's very scary what's happening with COVID tracing. At a national level, last year, 5 Republicans in the Commerce Committee co-sponsored a bill. It's S.3663. It's the 2020 COVID Tracing Privacy Act, Data Privacy Act. The regulation is awesome. It looks as buttoned up and maybe even more innovative than the CCPA. And it does a really great job, and it's very narrowly focused. So when Maymay on your podcast said he didn't see an appetite for a federal data privacy regulation that was sweeping, he's right. But I think it can be carved out one topic at a time. So in this S3663 in the Senate Commerce Committee, it stalled last year, and it was largely over something you've pointed out in your previous speeches and podcasts. And that is that the two hills that these politicians fight and die over are known as preemption. That's the federal government being able to preempt a state government's law, and private right of action. And that's sometimes couched as flooding the courts with frivolous lawsuits. So naturally, you see partisan wrangling on those two hills, and it's become so politicized and so polarized that you will have politicians arguing over a word as a knee-jerk reaction, even though they later hypocritically argue the exact opposite position on something. That the very politicians that are saying that we should not clog the courts with frivolous lawsuits are the ones that are complaining most about being deplatformed or censored by social platforms, and we think they should be held liable. In fact, they want to get rid of Section 230 so that they can be held liable. They're the loudest voices for private right of action. And yet when it comes to privacy and data regulations, we see them very vehemently arguing that, we should have no private right of action. So with this bill stalled last year, there's this really incredible opportunity. If I may go into one other vector for you, and hopefully we're not, because Sure. We're trying to peel that onion of a very large question.
Yeah.
With COVID mandated distance learning, what happened? Around the world, schools shut down. Kids were forced by law, by government mandate, to stay at home and distance learn. We've had conversations with numbers of technical directors and CTOs for school districts around the world. Largely, also, we focused in on New York City and also in Texas as well, to find out what's going on specifically in those regions, but in other countries and other states. And what we're hearing across the board, Debbie, is another, I hate to use the word reprehensible, it just seems to keep coming up. But some of our friends in the World Economic Forum told us an interesting statistic as we started researching this. Did you know that COVID mandating distance learning is impacting 1.2 billion children in 186 countries? Now, I don't think there's very many more countries than 186. So we can say this is happening in every country virtually. And what's happening from these technical directors' points of view is that when COVID hit, they naturally had already started some distance learning and some software platforms and some education through automation, but they didn't have the whole suite. They had gaps, and they're trying to fill the gaps for the children immediately, and they're not giving any additional budget. So candidly and largely off the record, they're telling us that they are signing contracts with software manufacturers and platforms where they are negotiating, they're bargaining the children's information rights contractually to these educational outfits. And talking to some of the chief executives of these educational outfits to try to piece this together, what are they doing with this data? Well, I don't know if you've seen the documentary Social Dilemma. I bet some of the folks that are listening to this podcast have.
Yeah, I've seen it.
And I don't say that they're going down this road with malicious intent. I'm saying that they're attempting to make their educational software the best that they possibly can be so that they can maximize their profits. But if your goal is to increase the attention of a child and get good marks from the teachers, then you start to see the software play and dabble in an area which was used to be considered unethical by teachers. And that's an area called tracking. So, it's totally possible that we could see an era coming up here where, and I'm just going to be very specific, if a young girl in the 5th grade doesn't seem to be doing very well in math, the artificial intelligence of the education might be skewed to keep her attention by introducing other topics and other subjects. They may start weighing that attention time so that the product is made better for the profitability of the company. Well, this could mean, potentially you're not very good at math, so let's do home ec instead. That's something you
Right.
might be interested in. Well,
Right.
what are we doing to the next generation, right?
Right.
So we have this massive problem that we need to address worldwide with children's data rights, and the Privacy Co-op is very, very active on working this. Well, if we realize that that's a problem, and we look at that bill that's in the Senate, S3663, which is around COVID tracing data privacy, we're almost one word away from saying children's data rights or educational, mandated distance learning, right? And the bill, as it's worded, could easily apply and be broadened with a sentence or two to apply to children's data rights. Now, what are we doing here? What am I suggesting? I'm suggesting giving parents the ability to opt their children out of these contracts that are being formed. And what does that do for the school board? Does that hurt the school board or help it? Well, the school boards are doing these negotiations without any leverage whatsoever. Their backs are against the wall. But if their parents are now starting to talk about opting out versus opting in for the data use, the school board can say, hey, how about if we work on the licensing through the guardians in a transparent way for you, the software company, so that you can become more compliant with regulations around the world. Now the school board has leverage in that negotiation. They're doing a job through an authorized agent like the Privacy Co-op or the Data Dividend Project. They're doing a great job of helping to almost commoditize or bundle information rights and guard them in a co-managed way. Now they've got a different chip in that negotiation, right? This is a different gambit that they're bringing to the table. This ultimately helps the children. It ultimately helps the guardians. And it can be done in an easier way than throwing the guardians 17 contracts that are 250 pages long and telling them to read through it and figure it out for themselves, right? So this is a great solution. So where this comes back into the federal law is we just had a change in the dynamics of the politics in DC, with Democrats taking over both houses and the executive branch, right? They already had the House, but now they have the Senate and they have the executive branch. Well, here's a bill that if we can just simply look at reevaluating our perspective on preemption and private right of action and say that these authorized agents can help kind of modify the thoughts around those two firebrands and say, this isn't about preemption. This isn't about private right of action. This is about organized nonprofits working to fight on behalf of parents, but take the rest of the bill as it's worded and apply it to children's data rights. I bet we would get 4 or 5 Democrat senators that could sign off on that very easily. And I think you would see a bill that's signature ready that could hit Biden's desk next week. This is something that's not going to take very long. And the impacts of rolling this out is as readily available. We don't need any more law. We don't need any more, necessarily money in, being spent on this. This is just simply giving people the opportunity to sign up with an authorized agent and applying their information rights right away to solve a very critical problem.
Wow, that's fascinating. I like the fact that you brought up the. I, I don't know. I don't know if I will use the word bias, but the idea that, and this is happening in a lot of AI, right? AI is to make decisions about people where they can put someone on a track that may damage them in the future. So just like you said, if Sally is not good at math, let's let her bake cakes instead or something. And then how does that information follow Sally through her life? Maybe
Oh,
she
yeah.
won't get into, more advanced classes in the future because somewhere some AI said that she wasn't good at math or something.
No, you're absolutely correct, and it's okay to use the word biased. I don't know where the political correct idea of algorithms being objective came along. Algorithms have never been objective. I've been in computer science, for the better part of my entire life, and algorithms are not objective. They're very subjective. Every single time I created an algorithm, I was trying to derive some point, right? I was trying to arrive at some value at the end. Of course, it's subjective. I don't know any algorithms that are innately objective. They would be almost meaningless to businesses if they were, and to computer scientists as well. So we got to start there and just say, let's throw that out with yesterday's news. Algorithms are very subjective, and we can go further to say that the intent of that subjectivity isn't necessarily malicious. I don't know a lot of, evil scientist software developers out there that wring their hand together and have that really great laugh where they go, I'm going to get them. I don't know anybody that does that. I think every data scientist and every software developer I've ever met is really after some really cool new innovation, and they really feel like they're helping people. It's just the unintended consequences of this thing, particularly with people not understanding their information rights. And that's the two words that you can put together: information rights. You put those two things together and you wrap up all of that publicity law that we were talking about earlier into a simple noun, proper noun. And if people start to understand their information rights and take action, that's what's really key. Yeah, I heard an interesting statistic just a couple of days ago. Did you know radio stations were more profitable last year than they have been in history? They had a revenue of $1.6 billion last year. And that was surprising to a lot of people because radio is sometimes thought of as kind of an antiquated communication medium. And yet the average artist whose music is played on radio makes, guess how much they get paid every time their song gets played?
How much?
Zero.
Oh,
The
really?
average. Now that's the average artist. Now, artists that are represented by BMI or ASCAP or some other authorized agent, you see what I did there? Authorized agent. Those artists that are represented by some authorized agent average 12 cents per time that their songs are played. And then you have representatives that have really great agents that get 19 cents per play. Now, Privacy Co-op last year, we have members that bought membership in the co-op, cost $25 for a lifetime membership, right? So they hired us to be their authorized agent. We went out and negotiated contracts and worked on their behalf. We had some affiliates that came on board just because they loved what we're doing, right? That's great news. We had affiliates that said, hey, we're not going to license the use of the information, but we still want to be an affiliate because we want to support your efforts. So as a nonprofit, what do we do with all that leftover income? We distribute it as dividends to our members. So our members made an average of $28.45 last year. So we like to say, hey, we actually beat a lot of the musicians that are being played on the radio last year. $3.45 doesn't sound like a lot until you find out that most musicians are only paid 12 cents per song if they have good representation. We want to get to the point to where, we're negotiating the color of your M&Ms in your green room for you as you're getting ready to perform your data output for the day.
That's really cool. Well, that's a good example. That's a great example. Get these laws to apply. And I don't know, there was some lawsuit that had come up about they want to use the Wiretap Act to apply to a case about the incognito mode of Google or something. I don't know. It just made me laugh, whatever it was. But yeah, I think, I actually think that we need a more comprehensive framework about laws and then figure out where all this stuff fits in. And I think there's definitely some updating and some pruning that's definitely needed. But I feel like we're just trying to contort our way through trying to apply some of this old stuff in ways that just don't matter anymore.
Yeah, you said tort there, and if I broke those two words apart in Latin, it'd mean with tort, which our lawyers might chuckle at. And if I baked a cake that's many layers high and called it a tort, it would be a tort. But if I take the torts that are applicable to what you just said, right, there's really four key torts that are involved. There's peeping Tom, publication of private facts. There is misappropriation. And lastly, there's defamation of character. Well, if you remember what we were talking about a little while ago with the difference between privacy law and publicity law, not all of those torts are privacy, right? You could say, I think you could make a pretty big argument that peeping Tom and publication of private facts are two torts that are heavily leaning towards the privacy side of this house. But misappropriation? No, that's taking, Cary Grant's photo and putting it on a box of Wheaties. right? That's misappropriation. And then defamation of character. Wow, there's, look at what's the opposite of that. Do we have laws around famation of character, right? It's contractual law where you can make a person famous, you can use their likeness, and use it for profitability, and they can license the use of their imagery, right? Of their likeness. So when you think about those torts and how they apply to what you were just saying, it starts to kind of answer those questions, but we really need to tease apart privacy from publicity law, because at the face of it, who doesn't want their incognito not peeped at, right? That is it a peeping Tom issue, or is this really a contractual right for publicity? So when you start piecing that together and realize that, well, actually, this might be more on the publicity side, we don't get our hackles all up about, I think you need to get a court order subpoena and it has to follow these regulations in order for us to find out a piece of evidence from crime. But this does ask a lot of questions. I think you recently talked about a Fifth Amendment argument around passwords. And I thought your content on that, your coverage of that was remarkable and thought-provoking. So I really appreciate your thoughts on that. I encourage your listeners to go back and check out your article on that in the past.
Oh, thank you so much. These things just really fascinate me more. I think my interest in privacy was more personal because I'm like, what is private to me? Like, what are my rights? So, that still sort of drives me a lot, even though I work with businesses as well. And so it's just fascinating to me. So to me, I
It
love to
is.
peel the onion back and talk about this stuff. So
One last thought on that peeping Tom piece. That really is trespassing.
mhm.
It's an interesting set of law that hasn't really been applied well to the digital age. But if you think about several hundred years ago, this is a eavesdropping. And I was talking to somebody the other day and I said, well, that's literally a thing. And they said, no, what? And I said, yeah, absolutely. Eavesdropping. Do you know where the word came from?
Yeah, the
It's
eaves.
Yes, in medieval time, you would trespass on somebody else's land. You would climb up on their roof and you would hang down from the eaves and listen in through the open window because they didn't have glass at that time. And you could hear what their plans were against your kingdom, right? So one fiefdom would send a spy into another fiefdom. And so in early law, they were saying, we don't want people hanging off our eaves. It became a trespassing issue. So peeping Tom is really that. There are some things you want on the internet to stay off the internet. You're just writing a letter to your mom and you're saying something personal. That's a created work of the mind, right? You clearly own the rights to it. It is concomitantly data and information fully, right? Data plus meaning equals information. And so that's an example when you're writing an email, the content is a creation. It is something very clearly covered by rights. It's all the other data, the metadata wrapped around that email, that it's going from point A to point B at this time and the subject is blah, blah, blah. That's all metadata. That's produced data. And it has rights, but it has a different set of rights. So right there within an email, you start to see the benefit of teasing apart privacy law from publicity law, right? And that's a great example where a person might not want them to monetize the content of their email, but they may be totally okay with monetizing the produced data around the email, all of the metadata, and therefore it falls into publicity law.
Right. Oh my goodness. I'm gonna have you back on the show. We have so much more to talk about. This is fascinating. Thank you so much. Well, before we end, I would love for you to tell people how they can contact you or get involved with the Privacy Co-op.
Yeah, sure. They can go to privacycoop.com. That's our website. I would, based on the subject matter we discussed today, I would probably direct people to do privacycoop.com/good. That'll take you to our social good. We're talking about children's data protection. We're also talking about a great subject, wrongful police profiling, which we didn't have time to get into today. Maybe we can follow up on that at some point in the future. And we also talk about COVID tracing exploitation there. So you can follow up on that. For others that are interested in maybe looking into us and supporting our work as a business, you can go to privacycoop.com/business. And then for everybody else that wants to become a member, just land on that main page. There's lots of content there for learning your, privacy rights, your information rights, and hopefully joining as a participant or a member in the privacy co-op.
Wow, that's wonderful. Thank you so much. I'm so happy that we were able to have this conversation. I know people are going to really love this because you really went down into the weeds on this one. So, which I like. So, this would be great.
Excellent. Thank you so much for having me on. It's been a delight.
Well, thank you so much. And we'll talk soon.